Hi, folks. My name is Greg McLawsen. I am now unmuted, and I am the Affidavit of Support lawyer. I have spent the past 10 years representing green card holders in federal litigation to enforce the USCIS Form I-864. Today, can you recover financial support under the affidavit if you are outside of the United States? Potentially, yes. We have done this for clients before, but let me walk through exactly what we mean by that question. So first of all, the Affidavit of Support becomes enforceable after you acquire status as a lawful permanent resident. So if you haven't yet acquired your green card and completed the residency process, the Affidavit of Support is not enforceable. So in this case of somebody outside of the United States, if you're going through consular processing, say you're in London trying to wrap up a immediate relative visa based on your marriage to a US citizen, if you haven't gone to your visa interview, had an approval, and then traveled to the United States and got your green card, then the Affidavit of Support isn't yet enforceable. Now, I don't see that coming up a whole lot in the context of consular cases, folks who are applying for visas outside of the United States, but we see it a lot in the situation where somebody's doing the adjustment of status process. That's the green card application based here in the United States. And it's pretty often that we see a situation where somebody applies for a K-1 visa, enters the US on a K-1 visa, and then they're completing that final step of applying for residency based on their marriage to their former fiance. And sometimes during that process, things fall apart. The marriage doesn't work out, and the person wants to know if you can enforce the Affidavit of Support. No, you can't, not until the green card is approved. So let's just assume that we're talking about somebody who's already gone through that process. They've acquired residency, regardless of whether it's through a adjustment of status process or consular processing. But we're talking about somebody who now has their green card. The Affidavit of Support remains enforceable until one of five terminating events have been met. One of those, the one that's relevant to this discussion, is loss of permanent residency and departure from the United States. You have to both lose residency and leave the United States for the affidavit to be terminated under that provision of the statute. What does that mean? Well, residents have the legal authority to leave the United States and return. That's part of your bundle of rights as a resident. So if you exercise that right as a resident to leave the United States for a period of time and come back to the United States, the Affidavit of Support has not been terminated merely by that trip. And that means that you can potentially recover financial support for that period when you were outside of the United States. Let me give an example of how I've seen that work out. So you could have a situation where a married couple has split up, and the foreign national, the green card holder, might go back to their home country to spend some time with their family, kind of while things are working out in terms of the divorce process, etc. If that green card holder goes outside of the United States and spends a few months with their family and then comes back to the United States, she's entitled to financial support, including during that period while she's abroad. There is nothing in the Affidavit of Support or in the statute that says, oh, and this financial support is provided only while the person is physically present in the United States. There's nothing like that. So we have had that happen multiple times in federal lawsuits where our client was mostly in the United States, but then had one or more trips abroad. And that doesn't change anything in terms of calculating damages, which is the financial support owed under the Affidavit of Support. Damages, again, that means the financial compensation that my client is due is calculated exclusively on the basis of her income. So Under current guidelines, 125% of the poverty guideline is what we look at, and that's currently about $1,400 per month. So if my client is unemployed, if she's in Texas for a month, unemployed, she gets $1,400. If she then goes to Lucknow in India for a month, she's still entitled to $1,400 per month, and then she comes back here. One way that we see, I've seen judges and opposing counsels get confused about this, is folks are aware that U.S. residents are subject to some limitations in terms of how long they can remain abroad. A lot of people have it in their heads that this is 6 months or a year. Actually, neither one of those is true. The factors under U.S. immigration law are actually more complicated than that. And what it actually turns on is whether you've taken actions inconsistent with your intention to remain a U.S. resident. Don't worry about those factors for now. What's important is that a person doesn't automatically lose residency by virtue of being outside of the United States. The U.S. government has to affirmatively take back that person's residency card. So I had a client who returned to South Asia for an extended period of time, came back to the United States, and her entry was fine. She didn't have any problem getting back into the United States. As a consequence, she still had residency and still had her physical green card. But the judge in that case spotted the issue of, isn't there some restriction on residents not being able to return to the United States if they've been out for a period of time? And the answer is yes, Your Honor, you are correct that there are limitations on long-term time abroad by a resident, but the resident doesn't simply lose their status by operation of law. That's a fancy way of saying automatically. So the fact that my client made it back into the United States, still has her green card, has not had proceedings initiated against her, means A, she is still a resident, and B, the affidavit of support is still enforceable. As a consequence, it was also enforceable for that period of time when she was outside of the United States. So in that case, it was something like for 4 or 6 months. And that did not change the calculation of damages in her case because, again, the affidavit was still enforceable for that period of time, and she was unemployed. So it accrues at that, what is currently $1,400 per month. So bottom line, yes, affidavit of support compensation can, under some circumstances, be recovered for periods of time when somebody is outside of the United States. To have a case under the affidavit, period, at all, under any circumstances, you have to first get residency. So if you haven't obtained residency yet, you don't have a case, regardless of where you are. But once you are a U.S. resident, you can travel just like any other U.S. resident. And while you are abroad, that does not change your entitlement to financial support under the Form I-864. This is something, again, that we have seen done successfully for our clients, even if sometimes you have to clarify that, no, there was not a loss of residency. The person returned to the United States and remains a resident. Because, again, only loss of residency and departure from the United States terminates the affidavit. One without the other has no consequence on the enforceability of the I-864. Hope that's helpful. This may be a very esoteric issue that it comes up in my practice, since this is something I do every day, but maybe this is of no interest to anybody else. We'll see. If you have questions about this or anything related to the I-864 and enforcement of the I-864, try to stump me, drop a comment, and I'm happy to answer a question of a general nature. If you would like a confidential case assessment, I do Zoom consultations all across the United States. Feel free to reach out to me on the website. Take care, everybody. Hope you're having a good week. Looks like it's going to be a hot one.